Thank you all for joining us today for the next installment in our webinar series, in our Moving Forward with Your Financial Health webinar series. We're so excited to have Eva LaManna and Monica Bryant here today with us, who are going to be discussing cancer and the workplace. This is part one of a two-part series, and this session is working during treatment. And then we actually will be having a second part to this series on December 13th about returning to work after treatment. So we encourage you all to sign up for that one as well. We're going to be posting the registration link for that shortly. So I'm just going to take a minute to introduce our presenters here and just a couple of housekeeping items. Hopefully you all were able to take a minute to fill out our pre-webinar survey. I know you're directed there automatically to our little SurveyMonkey site after you registered. If you have not had a chance to do that, if you're able to do it right afterwards, that would be fantastic. Just getting a sense of where you all are at right now. And then similarly, we're going to send you a link after the presentation to a post-webinar survey. And this data really, really helps us make the program stronger. So we encourage you to just take the 2 minutes to do, and we appreciate it so, so much. Finally, if you have questions throughout the course of the webinar, you will see that you are all on mute right now, but there is a little questions section in your control panel that you should be able to see on the right. And if you have questions, please just type them in. I will be fielding them throughout the presentation, and from time to time, we'll, when it's appropriate, we'll insert a question for our panelists. Otherwise, we will answer more of them towards the end, I believe. And if there are any that are very specific to your situation or we do not get a chance to answer them, I promise to pass them along to the presenters so they can get back to you, or I can get back to you later on. So without further ado, let me just introduce our presenters. Eva is a manager of programs at Cancer and Careers. And in this role, she does everything from coordinating events, including the National Conference on Work and Cancer, to managing the Cancer and Careers website in English and Spanish, and representing Cancer and Careers at conferences and seminars all over the country. Prior to joining Cancer and Careers, she worked with nonprofits including AIDS Athens, Animal Legal Defense Fund, and the Center for HIV Law and Policy. Eva holds a BA from the University of Florida and a JD from the University of Georgia School of Law. And Monica Bryant is a cancer rights attorney, speaker, and author, and she is the Chief Operating Officer for Navigating Cancer Survivorship, a nonprofit organization dedicated to providing education and resources on cancer survivorship issues. Throughout her career, she's provided numerous educational seminars across the country, written articles and blogs, and appeared on community television and radio shows discussing healthcare-related legal issues. Additionally, she's an adjunct law professor at the John Marshall School of Law in Chicago, teaching a class on cancer rights. We're so excited to have them with us today. This presentation will be archived on our website sometime in the near future, so you can go back and listen to it again at that time. So I'm going to pass the screen along here to Eva. And we will get started in a moment.
Okay, great. Thanks, Michelle. Thanks so much for having me here today. Just a little bit about Cancer and Careers. CAC celebrated its 10th anniversary last year as the only program dedicated to providing practical guidance and access to experts on all issues pertaining to cancer and work. From our accredited program for healthcare professionals to our online and print resources, we're your one-stop shop for credible information on balancing cancer and employment. Be sure to check out our website at www.cancerandcareers.org for up-to-date event listings, new publications, free online career coaching, and more. And Monica?
Hi, this is Monica Bryant, and thank you, SAMFund, so much for setting this up. We are always happy to work with you in Cancer and Careers. As Michelle mentioned, I do work for Navigating Cancer Survivorship, which is a nonprofit organization that provides education and resources on the entire continuum of survivorship issues. So that could be patient navigation, nutrition issues, employment issues, financial management. We talk a lot about health insurance options. And we do this education through resource and materials at our website, which is navigatingcancersurvivorship.org. We also have a blog with lots of guest bloggers and lots of seminars and teleconferences like this one today. So if you're interested in learning more about us, please visit our website. You can also find us on Twitter and Facebook. So I'm going to go ahead and pass it back off to Eva now.
Okay, great. So today you're going to get an overview from me and Monica about different employment, insurance, and legal issues that can arise when you're working through treatment. To start us off, I'm just going to share a story with you about Erin, who's really an example of the kinds of issues we hear and the questions that come up all the time. So after college, Erin worked as an assistant at a large company for 3 years. At the age of 24, she was diagnosed with cancer. After talking with her healthcare team, she decided her best course of action was to take some time off of work. Erin took COBRA to keep her health insurance coverage, but her 18 months are up and she's concerned about how to get insurance coverage with a pre-existing condition. Erin's now 26 and is ready to get back into the workforce. She isn't sure about how to deal with the gap on her resume and how to address it in an interview or if she even has to. Erin also has monthly medical appointments and has been experiencing chemo brain, so she's worried that all this will keep her from getting a job. Erin wants to know what her options are. So hopefully by the end of the call, you'll have a better sense of at least what some of Erin's options might be. So first I want to start with some of the more practical issues that arise when deciding whether to work through treatment. Given that everyone on the call is at a different point in their work and cancer dilemma, for some, the early decisions have been made or you've already had to change course, and for others, you're past the work and treatment question and on to wanting a new job. Still others are healthcare professionals looking for practical guidance on the whole work continuum. This presentation is going to touch on one of the biggest areas cancer and careers gets asked about, and that's working through treatment. When deciding about working through or soon after treatment, the first thing you really need to look at is the big picture. Think about the many often competing pieces to making a decision about work in light of your cancer diagnosis, some of which are always going to be in conflict with each other, but acknowledging that conflict and making an informed decision with that in mind is critical. Two key questions to ask here are how important is work to you, and what information do you need to make a decision about work? Some additional questions to consider are first, how will treatment affect your work and schedule? Work with your healthcare team. They can help you determine how much time off you'll need for surgery and treatment and help map out periods of productivity and fatigue during treatment so that you can determine if you can schedule treatment around your work. Options to think about are, how will you feel the worst on the day after treatment? If so, schedule appointments on Friday and use the weekend to recover. Or will the nausea hit 3 days after the treatment? Then schedule it earlier in the week so it'll hit on the weekend. Another question, what are your job demands, physically and mentally? This is where you really need to be realistic. Are there new barriers to getting to work? Is it uncomfortable to catch the bus now? How many hours, honestly, can you put in? What are other areas of your life, cooking, helping kids with homework, tending to aging parents, that take up substantial energy and really need to be taken into account? Also, how flexible is your work environment? In terms of those hours, can they be limited or flexible? And work assignments, can accommodations be made in either? Thinking further, what's the impact on your finances and your insurance if you take time off? Because, you know, the reality is that the Family Medical Leave Act is unpaid, and COBRA benefits can be very, very expensive. And unfortunately, sometimes this can make your decision for you. After the practical questions, it's really important to consider, how is your identity connected to work? For most people, it is deeply rooted in work. It's a reason to get up. It's tied to our sense of purpose, and not to be overlooked, it can also be a momentary escape from cancer land. Finally, consider, have your career priorities changed? Cancer is life-altering, and it's important to be mindful of that and allow yourself to reassess priorities. As part of your data collection, to best answer all the many questions that you're now asking yourself, you'll want to understand your treatment options and the specific recommendations from your healthcare team. Beyond that, you'll also want to know what the timeline for each phase of treatment is, what side effects are common, and any solutions for managing them. Simultaneously, you'll want to gather info from your workplace on everything, from leave policies to any pre-existing flexibility options. This is part of how you'll determine if you're going to work through it, take time off for some portion of treatment, or step away for maybe just a longer time. Maybe most importantly, assuming you've determined that work is an essential component of your overall well-being, you'll want to convey that to your healthcare team. This is really important because if they don't know that you want to work through treatment or get back to work as soon as possible, like right after surgery, for instance, then they can't take that into account in their plan for your treatment protocol and scheduling. They also need to know what your priorities are to help you best mitigate the side effects of treatment for the workplace. I cannot stress enough how critical it is to actually explain what you do day to day and what you want to be able to do to your healthcare team so that they understand. If you do decide to work, the next decision is whether to tell or not at work. I'd say the two major things to consider overall are, one, how treatment will interfere with your ability to perform job duties, and two, what legal benefits there are to telling, such as the ability to get reasonable accommodations. After those two questions, think through your work environment and culture. Is it a safe, flexible environment? Then maybe you want to tell early and fully disclose to people. If it's a more corporate or formal, then perhaps only tell what's necessary and when, and even then just the facts. If you're unsure, think about factors like, how long have you been employed at the company? What are your work relationships like? Is it close-knit with a lot of teamwork, or is it a little more isolated? How has your work performance been up until this point? And be really truthful and realistic here. If you've had poor performance reviews, then that could be an insurmountable obstacle when it comes to getting workplace support. Also think about, how have others been treated in similar situations? Was the company flexible? Are there policies like donated vacation time that made it easier on the employee? If yes, then these are good signs that the work culture is positive. Then you need to explore your individual personality and feelings about the cancer diagnosis. If you're outgoing, then you might want to be upfront and specific. If you're private, you might only want to tell as needed, if at all. Most importantly, you want to be true to yourself and know that everyone reacts differently to a diagnosis. So if you have decided to tell, the next challenge is going to be who. Who do you tell? I would recommend picking the person you're most comfortable with and starting there, especially since the first conversation can be the hardest. Your immediate supervisor is an obvious possibility, as they're often the person you work most closely with, and they can be an ally and an advocate within your company. If you don't feel comfortable with your supervisor, HR can be another great place to start. Their knowledge of company policy and benefits and their experience with other people who have gone through something similar makes them wealths of information. Finally, if you want to share with your colleagues, the best approach is to let them know what to expect. For example, fatigue or hair loss. Prepare them for what's coming up so they don't start guessing the worst. Then focus the conversation on how you plan to cope and get work done to alleviate any worries. People will take their cues from you on how to handle the situation. If you seem to have it under control, your colleagues will react accordingly. And for all of these conversations, just make sure to prepare beforehand so you're comfortable explaining your diagnosis, your treatment schedule, the effect on work, etc. Remember that everything's fluid and can change, so it's important to explain that too. And then, if possible, have a plan of action ready. Things like how you'll handle the work, when you'll be out, what's the best way to reach you when you aren't in the office, who will cover your workload when you are out, and any other details that will make this process easier for both you and your employer. I'm just going to switch it back to Monica now.
Thanks, Eva. So Eva has given you all some amazingly important questions and tips that you need to think about and consider before you decide if you're going to share your diagnosis at work. I'm going to now kind of switch gears a little bit and talk about the actual laws that may provide you some protections if you choose to disclose your diagnosis. And even if you don't choose to disclose your diagnosis, you may be entitled to some protections. So when we talk about employment law, we're talking about three main areas of the law. So the first is going to be the Americans with Disabilities Act, which is a federal law that deals with protecting people from discrimination based on a disability. It may also provide you with the ability to get a reasonable accommodation, which we'll talk a lot more about in a moment. Now, that's the federal law. There are also state fair employment laws that do similar things. And finally, we're going to talk about the Family and Medical Leave Act a little bit later. So those are the three main areas of law that will provide you protections. But it's also really important to look at your employment situation to see if there are other benefits you might be entitled to. So the laws are the bare minimum of what employers must provide you with. But oftentimes employers are more generous. So you want to make sure to check your employment contracts. If you belong to a union, check your union contract to make sure that you understand exactly what it is that your employer provides employees so that you don't, in essence, end up gypping yourself at some point. So let's start with the ADA. Again, the ADA is a federal law that protects people from discrimination based on a disability. The ADA applies to private employers with 15 or more employees, and then also state and local governments. Now, in addition to working for a big enough employer, there are two other hurdles that you have to jump in order to use the ADA's protections. So the first is that you have to be a qualified individual. Now, the legal definition of a qualified individual is that you can perform the essential functions of the job with or without reasonable accommodation. Basically what it means is you're qualified for the job that we're talking about. So if you want to be a commercial truck driver, you have a commercial driver's license. If you want to be an attorney, you pass the bar in the state that you want to practice in, right? Qualified for the job. The third hurdle is that you have to have a disability, and that's a disability under the ADA's definition. So under the ADA, a disability is a physical or mental impairment that substantially limits one or more major life activities. It's a total mouthful, I recognize, but let's break it down. So first is that you have a physical or mental impairment, and that's usually the easiest thing for people to figure out, right? You're going through chemotherapy treatment, you're suffering from chemo brain, you can't remember, where you put your keys, let alone what you had to do at work. So once you've figured out that physical or mental impairment, the next step is that that physical or mental impairment has to limit a major life activity. So major life activities are things like eating, breathing, walking, working can be considered a major life activity, and that was all fine and great. But in 2008, Congress actually expanded the definition of major life activities to include things like concentrating, thinking, sleeping, operation of major bodily functions. So for most people, this automatically reminds them of quite a few side effects that you get from chemotherapy treatment. So in essence, Congress really made it easier for people who are coping with cancer or going through cancer treatment to use the protections of the ADA. So we've got a physical or mental impairment, and that physical or mental impairment is limiting a major life activity. And then that limitation has to be substantial. So it's not just that you had one sleepless night that would mean that you have a disability. It's that you have, a week straight of sleepless nights or a month straight of sleepless nights. It really has to be a substantial limitation. Okay, so when you're thinking about a disability, it's also important to not just think about the cancer itself, because oftentimes the cancer itself is not, in fact, what causes you the problems of working through treatment, but rather it's the side effects of treatment. So it's important to think of both the cancer and also the side effects of any treatment. Okay, so now that we've established you work for a big enough employer, you are a qualified individual, and you have a disability under the ADA's definition, there are actually 4 ways to use the ADA. So the first is that you currently have the physical or mental impairment that substantially is limiting a major life activity. Right? You're currently going through cancer treatment, maybe chemotherapy, you can't keep any food down, and you're not sleeping. The second way is that you have a history of having a physical or mental impairment. So this might be a situation if you are a childhood cancer survivor, or maybe you're 5 or 6 years out from treatment, and although you're not currently suffering from any side effects or any issues, you're now being treated differently than everybody else at work because of your history of having a disability. The third way is being regarded as having a disability. So again, this might be a situation where you're one of the few lucky ones that is going through treatment and really isn't having very many side effects at all. Getting up and going to work is one of those things that makes you feel great about yourself and is really helping you get through this trying time. But the one side effect you've had is you've lost all your hair. And you go into work, and even though you're doing great, your boss now starts treating you differently because he or she sees that bald head and assumes that you can't do your job the way you used to. So you're being regarded as having a disability. Now, oftentimes, it's not necessarily that the employer is being malicious when they're treating you differently. So it could be that, your boss sees that bald head and thinks, oh, Jane's going through cancer treatment. I don't want to give her this big project because it's going to be very stressful, and I don't want to do that to her while she has so much else to deal with. So even though it's perhaps done to be nice or to be thoughtful, you are in fact still being discriminated against. Now, the fourth way to use the ADA is based on your association with a person with a disability. So this comes up for caregivers. Now, this is a much more difficult prong to prove, and it comes up a lot in the context of diseases like HIV or AIDS, where people aren't necessarily familiar with how the virus is transmitted. But it could come up in a cancer diagnosis as well. Let's say, for example, your boss was a caregiver to someone who had cancer himself or herself and knows how difficult it is to both be a caregiver full-time and work full-time. And so because of that knowledge, perhaps starts treating you differently, even though you're still able to do your job. Now, again, it's a little bit more difficult to use this prong, but the protection does still exist. Okay, so if you fall under the first prong, and the first prong only, which is that you currently have a physical or mental impairment that's substantially limiting a major life activity, you are, in fact, entitled to something called a reasonable accommodation. Now, the legal definition of a reasonable accommodation is any change in the work environment or in the way things are customarily done that enables an individual with a disability to enjoy equal employment opportunities. So that's the very legal definition, and I'm actually going to switch back to Eva so that she can talk about some of the more practical issues dealing with reasonable accommodations.
Okay, thanks, Monica. So I'm just going to talk a little bit first about ways to modify your workspace. It's really important to think about how you can make your workplace more comfortable and productive and modify it as needed. Simple things like set up your space so you don't have to expend any unnecessary energy. Maybe there's a special chair that's more comfortable, bring it in. Think about a backrest or pillow. If you sit at a desk, put your phone, files, printer, etc., all within easy reach so you're not always stretching everywhere. It may help to provide your supervisor with a letter of medical necessity for chairs or other equipment just to help ease this process. There's also ways to not only modify your workspace, but modify your schedule. A few options to think about when trying to develop a workable schedule, and of course, these aren't one size fits all, but just to get you thinking. Can you work from home part or full time? This can be great because it can eliminate a draining commute, or it can enable you to lie down when necessary. The key to successful telecommuting is to really structure the arrangement by setting up an agreement with your employer that sets down what hours you'll be working and goes over how you'll be reachable. Is it email or phone? and how you will indicate when you're away from your desk. Maybe you'll have away messages on IM, voicemail, and email. And also, you could go over what your equipment needs will be in advance: a phone line, computer, printer, access to office servers, etc. Can you maybe work a full-time but a flexible schedule? Is this a possibility? This would mean you would continue working full-time but vary the start and end times of your workday, or take time out during the workday to go to appointments and make the time up by working later that day or working later in the week. Another strategy is to work a part-time schedule during all or part of your treatment and recovery and ramp up as you're able. As I said, with any of these suggestions, it's going to depend on the kind of job you have. You know, a second-grade teacher, for instance, isn't going to be able to legitimately telecommute, but the trick is to be both creative and logical when you present solutions to your employer. And finally, I just want to talk a bit about a few more on-the-job strategies for working through treatment. One of the major workplace obstacles that we get asked about all the time is how to stay focused and concentrate. So some suggestions. Forget multitasking. Write down a list of priorities. Then turn off your email or phone and focus on one thing at a time. If you can, write everything down so if you forget, you'll always have a record. Write everything all in the same place. Keep a notebook with all your to-do things all in one place and take it with you everywhere. Rehearse everything from presentations to project updates and even phone calls. If you can, ban clutter and clear your desk or work area. And finally, remember to breathe. Try taking a break with a few deep breaths to refocus, or take a walk either around the office or the block. One more strategy. Identify a point person. Someone you trust, maybe a friend, family member, who's willing to be a centralized source of information about you, your health, and your schedule. Your point person saves you from having to constantly update everyone on how you're feeling. Your point person can also be your go-to person to find out what's happening at the office. The last bullet point is the hardest, for all of us really. But this is a time where it's critical that you're honest with yourself about your limits and that you can set fair boundaries about what you can and can't do, and stick to them. And I'm just going to give you back to Monica now.
So when it comes to reasonable accommodations, there are several legal issues that you have to think about in addition to sort of the practical issues. And the first one is, well, when do you ask for reasonable accommodations? And this is incredibly difficult for some people to figure out. And as with everything I think that Eva and I say probably all of today, there's no such thing as a one-size-fits-all. You have to look at what your job is, what your situation is when you're going through treatment to be able to answer some of these questions. So when do you ask? Typically, you're going to want to ask sort of earlier is better in this kind of situation, because if you sort of wait and say, well, let me see how going through treatment is and what I can still do at work, and then I'll ask for reasonable accommodation. If no one knows what you're going through at work, it may actually appear that your work product is suffering. And if people don't have a reason for that, you might actually be terminated or put on probation. So it's kind of one of those things where you probably want to ask for the reasonable accommodation before it gets so bad that you're in trouble at work. So how do you ask? And I get this question all the time. Typically, the person that you're going to want to go to ask for reasonable accommodation is going to be the HR representative. And it's not always, again, it depends on your job, but it could actually say in your employee manual who they would like you to go talk to as well. So that's one more reason for you to actually read your employee manual. But you don't actually have to say the words reasonable accommodation. Depending on sort of how good your HR rep is, it may be helpful for you to use those words. And the reason it might be helpful is because it will clue your employer into the fact that they, in fact, must provide you with these reasonable accommodations as long as you qualify under the ADA, and as long as it's not considered an undue hardship for them. Now, all of this is very subjective. but typically a lot of the things that Eva talked about aren't going to be undue hardship. So if you work in a typical office environment and all you're asking for is a different desk chair, that's probably not going to be considered an undue hardship. However, if you're that second grade teacher that she mentioned and you're asking to telecommute, it's probably going to be considered an undue hardship for your employer. It just isn't feasible. So not only do they have to provide you with a reasonable accommodation, assuming it's not an undue hardship, but they must absolutely keep your request confidential. So this information should be kept separate from your typical employee file. And even if you work in a very small office, the fact that you've asked for reasonable accommodation cannot just become general knowledge. So there's actually an interactive process that the Equal Employment Opportunity Commission, or the EEOC, which is the federal agency that oversees the ADA, they have this process that basically helps you figure out how to ask for reasonable accommodation and how to interact with your employer to, in fact, find the most appropriate reasonable accommodation for you. Also, I just want to give you this resource, which is the Job Accommodation Network, and their website is www.askjan.org. It's a government resource. It's a fantastic resource in my opinion, and I've gotten nothing but positive feedback about it from people who have used it. But they can actually help you figure out what might be an appropriate reasonable accommodation for you and your employer and your job. So if you are in this situation where you're not quite able to work up to the same capacity that you were before, and you're having some difficulties and you think that you need a reasonable accommodation, you're just not sure what that should be, I strongly recommend using AskJan. Okay, so I talked about the ADA, which is the federal law, but each state actually has a state fair employment law. They differ from state to state. Most are very similar to the ADA, but they can in fact be more protective, and they can be more protective in 3 ways. So some states actually have a broader definition of disability. So if you remember my original analogy that in order to use these laws, you have to jump certain hurdles. Well, you still have to jump the hurdles even if you even if you live in one of these states that has a broader definition. It's just that the hurdle is a little closer to the ground, a little easier to get over. Same goes for the states where they specifically list cancer as a disability. Now, that doesn't mean that if you have a cancer diagnosis, you're automatically going to be assumed that you have a disability. But again, it makes that hurdle a little bit lower. And finally, many states actually cover employers with fewer than 15 employees, which is a really fantastic thing, especially if you live in a state that has lots of small businesses or if you yourself work for a small business. So this chart actually shows the different states and their laws and how many employees their law covers. So I'll leave it up for a second so you can try to find your state, and I'm pretty sure that these slides are going to be posted later for you as well. But so if you look here, let's say you live in Illinois, as long as you work for an employer with 1 or more employees, you're protected. So as long as you're not self-employed and discriminating against yourself, you're good to go in all of those states. Okay, so we've talked a lot about the fact that you should talk to your employer, you should let them know what's going on, but we give that advice sort of cautiously because cancer is a very personal thing, and for a lot of people, they don't in fact want to sort of commingle the idea of their cancer diagnosis and their employment world. So generally, you do not need to disclose your cancer diagnosis. And in fact, the only time that you actually have to disclose that you have a serious medical condition is if you're trying to access the ADA's discrimination protection, if you're asking for reasonable accommodation, or if you're asking for medical leave, which we'll get to. But even if you're going in to ask for reasonable accommodation, you never actually have to use the word cancer. So again, for some people, it doesn't matter. Their diagnosis is out there. It's not a big issue for them. They can talk about the fact that they've been diagnosed. For some people, it's a very personal thing, and they don't want to say the word cancer. It's enough to say a serious medical condition. Now, you may, in fact, have to fill out forms and have your doctor sign off on the fact that you have a serious medical condition. And this goes back to Eva's original point of you have to communicate with your healthcare team. So if you're keeping your diagnosis confidential, make sure to let your healthcare team know that so that if they're filling out a form for you, they don't put down your cancer diagnosis. Also, be very careful of forms that your employer asks you to fill out because some of them might have a line for diagnosis. Or they might ask for your healthcare provider's specialty. And if your healthcare provider is the oncologist, the cat's sort of out of the bag at that point. So make sure you talk with your healthcare team, and if, again, you're keeping your diagnosis confidential, think outside the box. Maybe your general practitioner can be the one that actually fills out the reasonable accommodation form for you, and you don't have to then put down a specialty.
Monica, before you move on, can I ask a quick question?
Absolutely.
We had a question wanting to know about the slide showing the states and the number of employees that you need to be protected. This person wanted to know about Washington, D.C., where Washington falls on here.
That is an excellent question, and to be perfectly honest, I don't know off the top of my head. So actually, I'm thinking if it's not up here, it's 15 or more employees. So it mimics the ADA. Good question. There's always someone that stumps me with a state-specific question.
Yeah.
Any other questions?
Not so far. People should feel free to email them or I just got one more in here. This person said that they're working for a small internet startup that has just looks like 5 employees, and it's in California. And so she wants to know if that means that she's protected. Or does it have to be more than 5 or just equal to 5? Because she just lists a CEO, a CFO, and 3 employees.
So if it's 5 full-time employees, then I always hesitate to say things in absolutes, but I would say it sounds like she should be protected under the state fair employment law.
All right. Oh, now everybody's emailing questions, and we're gonna let you keep going, and then we'll just save them for the end.
Sounds good. And also, I just want to mention that when I talk about the state-specific information on our website, which again is navigatingcancersurvivorship.org, we do actually have a map that has state-specific information. We're still building it out, and we're adding things every day, but that's actually a resource that you might be able to find some important information for your state on. Okay, so I'm going to move on to taking time off work. So sometimes you're going to need to take time off from work. And many people are going to be entitled to do that because of the Federal Family and Medical Leave Act, otherwise known as FMLA. Now, the FMLA allows people to take up to 12 weeks of leave per year to take care of a seriously ill child, parent, or spouse or their own serious medical condition. Now, this leave is unpaid, which we'll talk about in a minute, but it's job and health insurance protected leave. So what that means is that you are entitled to these 12 weeks of leave, and when you come back from leave, you must be reinstated to the same or equivalent position that you were in when you left. So in other words, you can't be demoted for taking FMLA leave. Also, if your employer typically pays a portion of your health insurance premium, and you pay a portion of your health insurance premium, your employer has to continue paying that portion that they were paying before, even while you're out on leave. But that only applies for health insurance. So if there's other benefits that your employer contributes to for you, like disability insurance or life insurance, they are entitled to stop contributing to all of those policies while you're out on leave. But the moment you come back from leave, everything has to go back to the way it was before you left. Now, just like every law, there are some eligibility requirements. So the first requirement is that you have to work for a big enough employer. And for the FMLA, that's 50 or more employees within a 75-mile radius of your work site. So the 75-mile radius comes up for people who work in environments where there might be more than one work site. So think bank branches or chain restaurants or even some hospitals that may have external clinics. If you count up all the employees within a 75-mile radius of your work site, and that's more than 50, then you've satisfied that requirement. So in addition to working for a large enough employer, you have to work for the same employer for enough time. And that means that you have to work a total of 12 months, and that's cumulative. So the federal law actually says we will look back 7 years, and as long as you work for that employer for a total of 12 months in that 7 years, and in those 12 months worked at least 1,250 hours, you're going to qualify. So the 1,250 hours comes out to be a little bit more than part-time. Okay, so there are some practical things to think about when we talk about the FMLA. FMLA leave can be taken all at once, so you go out for 12 weeks, and that might be a case if you've had maybe a complicated surgery and you need the 12 weeks for the surgery and the recovery. Or you might want to take it intermittently. So maybe it's just that you get your chemotherapy on Thursday, and it's really just the end of Thursday and Friday that you feel terrible, but by Monday you feel ready to work again. So maybe you're just going to take Thursday and Friday off until you add up to your 12 weeks. Also with the FMLA, it's important to recognize that you should inform your employer your need for leave as soon as it's foreseeable. So if you've had a surgery scheduled 6 months from now or 3 months from now, you should make sure to tell your employer immediately. Sometimes it's not foreseeable, and then you should really tell them within 1 to 3 days of that leave. Now, also, we talked about reasonable accommodations. And this is one of those areas of the law where the two laws can actually work together. So you might actually be able to take your 12 weeks of leave, and then let's say your doctor says to you, you're doing great, but I just want you to have one more scan next week before you go back to work. You may, in fact, be able to contact your employer and say, thank you for my FMLA leave, but now, as a reasonable accommodation, could I have an additional week off or month off or whatever it is? Now, the employer has to provide that to you as long as it's not an undue hardship. Now, it may very well be an undue hardship, especially if, you are in perhaps a high-level position and you've already been out for 12 weeks. It might realistically be an undue hardship for them to give you additional time off, but it might not be. Also, the trick with using the ADA and the FMLA together this way is that the additional leave time has to be for a specific period of time. So you can't just call your employer and say, thanks for my 12 weeks, but I'm still not really feeling great. I'll give you a call in a couple weeks and let you know. And that's my reasonable accommodation. It doesn't really work that way. It has to be for a specific period of time. And also, it is important for people to realize that your employer is absolutely entitled to get medical certification showing that you are, in fact, taking care of your own serious medical condition, or you're a caregiver to a child's parent or spouse with a serious medical condition. And all of the items that I talked about before about being careful of forms apply here as well. Because you
Monica, I'm sorry. Sorry, can I interrupt you? I had a question
Absolutely.
that related directly to what you were just talking about. I had a question from someone who said that her doctor has written her an ongoing recommendation to work from home after treatment because of anxiety that she's developed with regard to the exposure to potential carcinogens at her workplace, which is a chemical company. And she wants to know if this is considered a reasonable accommodation under the ADA even after treatment has ended.
It should be considered a reasonable accommodation because the question is about, do you still have a disability? So do you still have a serious physical or mental impairment that limits a major life activity, that substantially limits a major life activity? So if it's that you have a weakened immune system due to treatment where you're now more susceptible to carcinogens, then that is in fact probably going to be a disability, and then you would be able to get a reasonable accommodation. But that only, again, works if working from home is, in fact, a reasonable accommodation for her job.
Right. Just a follow-up question to that, I think it was actually the same person who said that when she requested a reasonable accommodation to work from home while undergoing treatment, her employer required a release of medical records to substantiate her doctor's recommendation, and she wanted to know if this was actually legal.
So that's a great question. And we actually get the question a lot because employers will ask for medical records. And legally, you do not have to share your medical records. Because of HIPAA, your medical records are private. Now, your employer or her employer could ask for a recertification from her doctor saying that this is in fact true and this is medically necessary and this is what's going on with her, but they are not entitled to look at her actual medical records.
Great, thank you very much.
Sure. Okay, so because I want to leave enough time for other questions, I'm just going to quickly talk about some income options because I recognize that for most people, taking 12 weeks off unpaid is just not a feasible idea. So that's where disability insurance comes into play. And there's different types of disability insurance. There's some private disability insurance that you can purchase through your employer. I'm sure we've all seen the Aflac commercials with stuff. That's a perfect example of disability insurance. Some states have state disability insurance, but there's very few of them. And then there are two federal programs, so Social Security disability insurance and supplemental security income. And I could talk for an hour just on these two programs, but if you've got questions about them, I'm happy to answer them, and we should also be posting a blog about them at some point in the near future as well. Also, there are some other financial assistance options. So some states have programs that will help you pay for your insurance premiums. And then there's a ton of cancer organizations that will actually help with direct financial assistance or help with co-payments or prescription drug assistance. And again, we've got some of that information on our website. We're always building out more. And then lastly, some other resources. If you feel like you've been discriminated against or if you feel like you want to talk to an actual lawyer, I would recommend that you check out the National Cancer Legal Services Network. And this is a network of all different types of legal services organizations all over the country that specifically help people who are coping with cancer. And then I mentioned the EEOC and Ask Jan for questions about reasonable accommodations, and of course the Department of Labor. So I know this is going to be posted, but Eva and I have given you our contact information, so you can find us after this. And if you do have questions about returning to work, we're going to have another webinar in a couple of weeks. So with that, I think I'm done, and I'll pass it back over to Michelle. Thanks so much.
Great. Thank you guys so much. This is just really terrific. There we are. So if anyone has other questions, I think the only questions I have are from the person who was asking about about the 5 employees. If it's only a CEO and a CFO and 3 other people, she would just followed up wanting to know if it matters whether they're hired by an international company. Does it have to be a U.S. company in order for the state laws to apply in terms of the employee, the state fair laws?
Well, that's a tricky question.
Sorry, I know it's very specific, but we don't have any other that I'm seeing right now.
I would say probably not, especially because chances are you're paying income tax in the state, so there's some mechanism for you to be legally employed in the state, even if it is a foreign country, so the state laws should apply.
Great. If anyone has other questions, then please send them in right now. Otherwise, we will wrap things up. I'm just seeing a couple thank yous. So I think certainly if people have questions that come to them later, please feel free to send an email to webinars@thesamfund.org, and we will pass them along to our presenters. Thank you again so much to Monica and Eva for their time and expertise. This is so much terrific information. I think it's going to be helpful to a lot of people. So folks who are interested in getting the slides or in being able to view this webinar again, we will have this all on our website. Probably it may take us a couple of days longer than usual because we are actually in the process of getting ready to launch our new website. So please be patient if it takes a little bit longer to get it up there for you, but we will have those up there for you. And for everyone who can, if you can please just take a minute to complete our post-webinar survey. The link is down below here. We really, really appreciate it. And again, keep an eye out for the link. We'll be probably posting that tomorrow on our Facebook page, and we'll send an email out to everyone on our email list with the link for the part 2 of this installment of this series. So please join us for that as well on December 13th. So thank you once again for joining us, and hope everyone has a great afternoon. Thank you.